I do see that he's an attendee right now. It's D Bay.
Yes. Yeah, I promoted him to a panelist. We'll see. He
Okay.
should be joining now.
Hello.
Good morning.
Good morning, Attorney Bay.
Morning, Your Honor. Good morning.
So now that everyone's here, we can get started. Good morning, everyone. Today is Tuesday, August 6th, 2024. The time is 9:31 a.m. And this is the status conference in the matter of William Farwell, case number 23-012-S before the Massachusetts Peace Officer Standards and Training Commission. We are convening remotely via Zoom, and this status conference is being recorded. This is a public hearing and proper notice has been provided. As a reminder, please use initials when referring to the individual involved. The Honorable Judith A. Cowan, retired Massachusetts Supreme Judicial Court Justice and Hearing Officer for the Post Commission, will be the presiding officer over today's status conference. My name is Lizzie Smith, and I'm the Hearings Administrator for the Post Commission. This matter is now before Judge Cowan.
Good morning. Good morning, Counsel. Would Counsel identify, themselves for the record, and also Attorney Bay state, please, whether your client is present?
Good morning, Your Honor. My name is David Bay. I represent the respondent, William Farwell, and he is not present.
Good morning. I'm Sean Martinez, and I represent the Division of Police Standards in this matter.
Okay. Before we go any further, let me just ask the status of the possibility of any resolution of this matter.
Well, Your Honor, the respondent certainly remains open to resolving the matter short of decertification at any time.
Mr. Martinez?
Yes, Your Honor. So the agreement that we previously submitted to the commission that was rejected was essentially an agreement that was as close to decertification as we could get without actual addition to the National Decertification Index, and it was again rejected by the commission. I don't anticipate that without voluntary decertification that we'll be resolving this matter prior to a hearing.
Okay. So I assume, Mr. Bay, your client is not interested in a resolution such as his twin brother accepted.
He is not, Your Honor.
Okay. Then regarding the motions in limine, the CJIS queries, your position, Mr. Bay, is that 24 of them the queries were on himself, on the respondent himself, is that correct?
That's what I understand the allegation is, Your Honor. And just for some background, Your Honor, my client was taught during his CJIS training that in order to test the system, you query yourself. So it's really just following the directions of the CJIS instructions.
And his position is that 24 of the queries were of himself?
Well, that's what the records allegedly show, Your Honor. He doesn't have any direct personal knowledge or recollection of it, but that's what the records purport to show.
Okay. Well, 24 over what time period is the allegation?
I believe it's an approximately 3 to 3.5 year period.
Okay. Okay. And then, Mr. Martinez, the allegation is that two of these CJIS inquiries were related to SB. Is that correct?
That's correct.
Okay. Now, Mr. Bay, your argument is that the division should not be permitted to refer to SB as to these two, what they claim are two improper CJIS queries, correct?
Yes, Your Honor. We filed a motion in limine on that issue.
I understand. Okay, Mr. Martinez, what is the problem as far as the division is concerned with stating that there were two allegedly illicit searches with this person can be identified in any one of a number of ways, with a friend, with a person with whom he had a romantic relationship, with a person outside law enforcement. What would be the division's problem with referring to these illicit searches in that manner? And I mean, illegal searches in that manner.
Yes, Your Honor. So the issue is that in particular, the charge under MGL Chapter 60, Section 10, subsection B, subsection Roman numeral 3, the burden of proof that the division needs to meet is that the commission finds by clear and convincing evidence that the officer has a pattern of unprofessional conduct that the commission believes may escalate. And the discipline, if we do meet our burden of proving this pattern of unprofessional conduct that may escalate, is discretionary, that the commission can either suspend or revoke an officer certification. The division's position is that the relationship in particular between SB and William Farwell really informs upon the level of unprofessionalism that William Farwell engaged in and would be important to any discretionary discipline that the commission would impose. Additionally, just as far as evidentiary support, practically speaking, admitting exhibits to the hearing, the information relating to SB makes up a huge portion of the internal affairs report, of all the documents, of the alleged statements to the Massachusetts State Police involving a wrongful death investigation. All of these facts are inextricably woven together. There's no way to separate the fact of the origin of their relationship from what occurs later. The level of unprofessionalism, again, related to the CJIS inquiries, is different when it's a romantic relationship between the officer and the person that he's querying. And it becomes even a different level of unprofessionalism when it's somebody that he met who was essentially an intern at the police department. And that's how their relationship began. And then also that there are text messages that show that his twin brother had a sexual relationship with the same individual when she was underage. All of this information is important to the commission's discretion, important to the appropriate discipline. It's important in determining whether or not his conduct may escalate.
Okay, and you said that the information about SB makes up a huge portion of what? I missed.
Of the internal affairs report, also of the investigation that the Massachusetts State Police engaged in during which William Farwell was interviewed, which is one of the allegations that he was untruthful during the interview relating to SB's death.
How do you respond to that, Mr. Begg?
Your Honor, there's a number of issues I take with that, Your Honor. This is William Farwell, Your Honor. This is not his brother, okay? And William Farwell, in this case, is not charged or not charged with any type of conspiracy with his brother or others within this Explorers program to interact in a sexual manner with SB. That is the nature of the claims in the wrongful death lawsuit that is asserted in the Norfolk County Superior Court, Your Honor. That is not what we have here. And I've heard a number of things from Attorney Martinez here this morning that have nothing to do with the allegations that have been asserted against my client here. Let's be clear here, Your Honor. There are 3 allegations against my client, and only 3 allegations. Number 1, he misused CJIS. Number 2, he was sexting while on the job. And number 3, he allegedly lied to state police when he told them the last time he saw SB was in December of 2020, when in fact the state police was able to locate a text message on January 10th of 2021, just 10 days after December, where the state police claim that it shows that SB and my client had met up in person. Those are the only 3 allegations. There is no claim, there is no allegation of unprofessional conduct, or unbecoming. It's those three specific categories, Your Honor. And quite frankly, Your Honor, all those three specific categories can be alleged and evidence could be offered with removing SB's name in its entirety. It has no connection to the actual SB person.
Okay, I completely understand that, but you just said no charge of unprofessional conduct. Yes, there is a charge of unprofessional conduct. All the charges relate to unprofessional conduct.
I understand, but the factual basis supporting the allegation of professional conduct are just those three allegations, Your Honor. It's not a wide sweeping conspiracy type of theory like is asserted in the Norfolk Superior Court. That's not what we have here. This is simply those three specific enumerated claims that are set out in the order to show cause. That is what is alleged to be unprofessional, nothing else.
Well, but Mr. Martinez claims that the fact that it was a romantic relationship would inform the fact that he that would inform their burden of showing his unprofessional conduct, and it would affect the discipline that may be imposed.
And that's fine, Your Honor. You can the DPS can go ahead and allege that there is a sexual relationship between my client and a female. They don't have to name Sandra Birch. They don't have to name the SB. They don't have to do that. The only reason why you would inject SB's name into this is to garner some sympathy or some rage, whatever it may be, from the commission, Your Honor.
Okay, what is the first thing that you said? It's all right, let them do what?
Now, they can go ahead and allege that my client had been sexting with a female. Simple. They don't have to name SB. That is not germane to their allegations against my client, Your Honor.
Okay, are you saying sexting with an S?
Yes, yes.
Okay. Mr. Martinez, what would be the problem with your seeking to establish that the respondent had been sexting with a female, not his wife, not a family member?
Again, Your Honor, all of the things that Attorney Bay is referring to, he's leaving out the integral part, which is with SB. Even in the order to show cause, all of the allegations.
Why does it matter whether it's SB or XY? If it's a female not related to him in any way, and he's sexting with an X, why does it make a difference whether it's SB or XYZ?
Your Honor, whether or not it's a female or we use the initials SB, the concern for the division is that we're able to discuss the underlying facts. In other words, that this female individual, even if we refer to her as a female individual or SB, that she was the one that whose death MSP was investigating, that she was the one that Officer Farwell was engaging in sexual text messages while on duty, and that this female individual is the same individual who also was the subject of the CJIS inquiries that the division is alleging were illicit.
Well, that can be done. That can be done without naming the person. What I don't understand is why it makes a difference whether it's Patricia Jones or Evelyn Smith. If it's another person, why does it, another woman with whom he's having a relationship, a sexual relationship, not his wife, why does it matter who it is?
Your Honor, so again, the level, if the only concern for Mr. Bay or Attorney Bay is that it's SB versus a female individual who happened to be an intern when Farwell met her and who he later developed a sexual relationship, the division doesn't have an issue with using a female former intern at the Stoughton Police Department. The issue is, I believe Attorney Bay is arguing further than that, that the division should be precluded from mentioning that the wrongful death relates to the same individual that's a CJIS, that was the subject of the CJIS inquiries, that the state police, I believe that he's arguing that the fact of the state police that they're investigating the same individual should not be come out at the hearing, and that it should not be a subject of the hearing. Whether it's SB or a female individual, the division should be able to give context because it's going to inform the commission. The division does not have an issue with how we discuss this individual. It's the matter that the context is extremely informative to the level of unprofessionalism, to whether it may escalate, and it's extremely important to the commission that they have context.
Your Honor, if I may, Your Honor,
Go ahead.
just that description, Your Honor, that Attorney Martinez just gave, it leads me to conclude that this is essentially going to be a mini wrongful death trial, which it really should not be in any way, shape, or form. That is not the purpose of this forum. This forum is to litigate and decide the allegations of professional conduct, the 3 enumerated allegations of professional conduct that has been asserted by the DPS. This is not about the wrongful death of Sandra Birchmore. This is about the allegations of unprofessional conduct by William Farwell that has been alleged by DPS, Your Honor. So and Attorney Martinez is correct. My motion was meant to fully address that the respondent is moving to preclude any reference to Sandra Birchmore, SB, any reference to this prior alleged meeting during the Explorers program, because it has absolutely nothing to do with the allegations against my client in this forum. SB will have her day in court, and she has a forum already in Norfolk Superior. There's no way she should have. There's no reason why she should be have 2 different forums, and she's not even a party to this case, Your Honor. This is about William Farwell.
Okay. I understand both the positions. And I just want to restate, the respondent would have no objection to referring to a female outside the family with whom he was having a sexual relationship.
That's correct, Your Honor. It does not have to be the initials SB. We don't need to identify the individual to that extent.
Well, Mr. Bay, would you be content with that?
I would be content with that, Your Honor. I think that's appropriate.
Okay, I'm not indicating how I will resolve this, but I just want to get the parameters in my mind. So the remaining difference is that she was a former intern and that there was a wrongful death investigation. Am I correct on that, Mr. Martinez?
That's correct.
Okay, Mr. Bay?
That is correct, Your Honor, but also the fact that, she allegedly committed suicide, and that all those facts surrounding that. Basically, Your
If
Honor,
she allegedly committed suicide, I'm sure will not be coming in, Mr. Martinez, correct?
That's correct. Our position would be that the Massachusetts State Police was investigating the death of that individual, not that it was a suicide or murder or a wrongful death, just that they were investigating the death of that individual.
So it was a investigation of the death of that person. All right, well, Mr. Bay, would you have any objection to a statement that the state police were investigating the death of the person with whom he had the relationship?
I think that would be fine. Just simply they're investigating a death, and that's the last time they saw the person. I think that is fine.
All right, so we've narrowed it down to one point of dispute here, the reference to her as a former intern. I think I'm correct on that, right, Mr. Martinez?
Yes, I do just want to be clear that the way that Stone Police Department refers to these individuals is that they're members of the Explorers program.
Okay.
But just informally, I believe it's very similar to an intern or a sort of like a high school trainee. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . .
But there's no allegation here that he had any improper relationship with her when she was a minor.
That's correct.
Okay, right. So does Mr. Martinez do the allegations? Was she working for the Stoughton Police Department at any time that's encompassed by the allegations here?
I don't believe so, Your Honor.
I don't think so either.
Yes, I don't believe
Oh,
so.
all right. Okay, that's why I asked that. All right, Mr. Bay, would there be a problem if she were referred to as a former member of the Stoughton Police Department?
Well, truth for Your Honor, I don't see the reason for having her, for the fact that she is a member or not a member of the Stoughton Police Department. I'm not sure, I don't see how that has any relevance to the claims against my client here. And I think that would lead to more tipping off of the commission about who we're talking about. And just so you know, Your Honor, there's been a ton of media on this. So I think that I think simply the fact that my client's name is going to tip off the commission, quite frankly. So anything additional would certainly let them know what we're talking about as far as SB.
Well, Mr. Martinez, why then do you believe that it would affect the level of discipline that she was a former member of the Stoughton Police Department? According to what I can understand, the allegations, none of the allegations apply to when she was a minor, nor to when she was a member of this intern program. So why is the level of discipline or the level of professional misconduct affected by the fact that she was a former member of the police department?
Your Honor, not just a former member of the police department, a former member of the police department's Explorers program, which is a program designed for high school individuals to determine whether or not they're fit for the law enforcement profession. The origin of their relationship, I believe, reflects upon the power dynamics between the two. We have somebody who was in a position of power, William Farwell, who met this individual as an explorer and later developed a sexual relationship with with that individual.
But at the time of any of the allegations here, he was no longer in a position of power over her.
Well, in the order show cause, the division does allege that they met while she was at the Explorers program. But as far as the misconduct that William Farwell engaged in, the origin of their relationship is for context. There is no direct misconduct allegation as to when the individual was a was younger than the age of consent.
Okay, I understand the positions of the parties here, but yeah, go ahead.
I'm going to just say, Your Honor, the fact that SB was in the Explorers program, again, has absolutely nothing to do with the claims against my client in this form. It could simply be an ex-girlfriend of her. It has the fact that she was in the Explorers program, again, is only offered in order to inflame the commission here, Your Honor. It has nothing to do with the claims against my client, and quite frankly, it is improperly being used to enrage the commission, because there has never been, not in this case nor the Norfolk County Superior Court case, a scintilla of evidence that my client had sexual relations with SB while she was a minor. It has never been alleged, and there's zero evidence to support it. And suggesting that they met during this Explorers program is putting a piece of misleading information into the commission's mind that is unfairly prejudicial to my client.
Mr. Martinez, that is a salient point. The fact that that he knew her while she was a minor, she was in that program. Why should that affect any discipline or any level of any burden that you have when there's no allegation that he had any relationship with her other than a professional one when she was a minor?
Yes, Your Honor, I believe that it's relevant. I believe that the commission is going to believe it's relevant, and they are commissioners who deal with this type of evidence all the time. Even if submitted, they're not going to draw conclusions that are not there. They're ultimately the finders of fact. These are relevant facts that inform upon the level of unprofessionalism that William Farwell engaged upon. Further, as I mentioned before, in the text messages, there's even references to the fact that William Farwell is aware that his twin brother had a sexual relationship with this individual when she was a minor. That further goes to the power dynamics of the situation, and I think further reflects upon the unprofessionalism of William Farwell. I do think that it's very relevant to the level of unprofessionalism. It's very relevant to whether his unprofessionalism will escalate.
But if the text messages come in as evidence, then won't what you just said come in as evidence?
That's correct, Your Honor.
So that, okay, I understand what the issue is here. Now let me see. Well, speaking of the graphic text messages, again, my question to you, Mr. Martinez, is what does it matter to whom he sent them? If they're on his phone, and if it can be established that he exchanged them with someone, obviously a female, while he was on duty, why does it matter who the recipient was?
Your Honor, I'm not sure that I can offer any additional information other than what I've given already. I believe that it informs upon the level of unprofessionalism. It's a discretionary charge. It's not black and white. The discipline is not either or. The commission has the full discretion if the division proves its case to impose no discipline, to impose a one-day suspension, all the way up through revocation of his decertification. And the context of each of his acts of unprofessionalism, and again, the evaluation of whether or not it will escalate, all of this information is important.
Okay, Mr. Bay, do you have anything to add?
Your Honor, just that, Your Honor, in deciding these motions, eliminate, Your Honor, I beg that you really review the order to show cause, Your Honor, the 3 enumerated claims of unprofessionalism that have been asserted by the DPS, Your Honor, because they really do have nothing to do with this overall theory of my client and others within the Stoughton Police mistreating SB, which is the subject of the Norfolk Superior Court case.
I reviewed them as recently as yesterday and plan to review them again
Thank you.
before and during and after the hearing. So I don't think you have any problem there, but so your argument is essentially the same also, and I understand the argument. Okay, as far as his allegedly untruthful statement to the state police about the last time he and SB were together, I understand it's a short difference in time. And again, is there any additional argument as to why it's necessary to give the name or to give the initials of the person with whom he met? Mr. Martinez.
I don't believe so, Your Honor. From the division's perspective, it doesn't matter if she's referred to as SB or as a female.
Let me just ask you, aside from the other two issues, would the division be content with referring to the investigations to a death investigation, a state police death investigation with someone, with a female with whom we had a prior relationship?
The division's position would be that again, the context of when they met is important to the case that the division plans to present at the hearing.
Okay, and Mr. Bay, your argument is the same?
Well, I think your suggestion, Your Honor, I think was fine. You know, no need to refer to SB or the context of their meeting, just the fact that they had a prior relationship, I think is certainly sufficient.
Okay. Now, the CJIS search results, the problem there, as I understand it, is that respondent claims there was a hearsay problem here because of the spreadsheet. Mr. Martinez, why is it necessary to have a spreadsheet? I'm very non-familiar with computer anythings, but what would be the problem? Okay, you want to show the dates on which he made CJIS queries, correct?
That's correct.
And that they were improper, outside the scope of a law enforcement responsibility. So why do you need a spreadsheet? Couldn't you just say that on however many different dates you want to establish it, someone could testify that on May 24th, he made an improper CJIS inquiry. On May 25th, he did it, on the 26th, 27th. Why do you need a spreadsheet?
Your Honor, the spreadsheet is, as we represented in our motion, we do believe is authentic and is the type of evidence that reasonable individuals.
That isn't my question.
Yes.
Why do you need a spreadsheet rather than some person who has examined the records, the keeper of the records, whatever, come in and say that on that date, he made CJIS queries that were not related to law enforcement?
Yes, Your Honor. I believe Attorney Bay would have the same issue, claiming that it's hearsay and unreliable hearsay. The point of the records.
Why is it, if it's a business record, why is it hearsay?
Your Honor, it was Attorney Bay's argument. I would argue that it's not hearsay, but.
I understand, but I'm not asking you about the spreadsheet right now. I'm asking you about the keeper of the records from the Stoughton Police Department coming in and testifying. It was a record kept in the normal course of business, blah, 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 and kept before this hearing, this charge was brought, and he made this, and that queries on such and such dates. What is the problem with that?
My anticipation would be that the records came from CJIS and that Attorney Bay would argue that it's hearsay because the records are not Stoughton's, but CJIS's. But I can't anticipate Attorney Bay's argument.
I'm asking, that's right. I'm asking what
you.
So you could bring in the keeper of the records from CJIS, who would say what I just indicated. What would be your problem with that? I mean, I don't understand why you need a spreadsheet just because we now have computers and there are now spreadsheets. Before, it would just have been somebody, a keeper of the records, coming in and saying, on this, and that date, these queries were made, and they were not related, in his opinion, if he's permitted to give it, they were not related to law enforcement.
Yes, Your Honor. It's unnecessary for a witness to come in and testify and inconvenience a witness when we already have the authentic records underlying the charges. And the person who would testify would testify, what I would anticipate would be that they reviewed the records that we already have, and that they determined based on those records that there were these CJIS searches made. We can save inconveniencing a witness, we can save duplicative evidence by including the spreadsheet and accepting it into evidence rather than needing a witness to authenticate records that we believe already have sufficient authentication. And as you stated, these are business records that likely do not constitute hearsay, and they're the type of records that would be admissible typically in an administrative hearing already.
Well, who would be introducing the records if the witness didn't come in?
It could be the Stoughton internal investigator, or quite frankly, we don't need an authenticator because they're the type of records that we received from Stoughton, and they're the type of records that reasonable persons rely on in the course of business.
Well, somebody would have to authenticate them.
Then, Your Honor, I imagine that it would be the Stoughton internal investigator who received these records from CJIS. However, as we noted in our motion, there's a protective order in which somebody from Stoughton represents that these are CJIS records. There's also a letter directly from CJIS that refers to this document that shows all of William Farwell's CJIS records or CJIS searches.
Okay, Mr. Bay?
Your Honor, the document that Attorney Martinez is referring to is a simple letter from CJIS to Stoughton Police Department, Your Honor. It is not an affidavit, and no one has attested that these are actually complete and accurate CJIS records, Your Honor. So I would agree with you that someone does need to authenticate these records. And Your Honor, if you give me an opportunity, I would like to show you these records to show you how extremely confusing they are and why authentication is needed. One of my clients' defenses is during these is that Sandra Birchman was regularly in Stoughton by her own account and by others' accounts.
I'm sorry, I didn't hear the beginning of that.
I'm
The
sorry.
beginning of the last sentence. The beginning of the last sentence. I didn't hear that somebody was regularly in Stoughton and regularly.
I'm sorry. SB was regularly in Stoughton by her own account during the years of these alleged searches, Your Honor, 2019, I think, to 2020. And Your Honor, these my client's position is that if there was a search of her name on 2 occasions during these 2 years, it was done by a license plate, and he's running license plates, 15, 20, 50 a day as he drives around Stoughton, Your Honor. So the fact that he may have picked up her license plate in one of these searches, Your Honor, is completely reasonable, Your Honor. But the fact of the matter remains is when you look at these CJIS records, Your Honor, they are essentially a mess. I'm looking at one of these alleged searches, Your Honor, that was done on November 4th of 2019.
Attorney Bay, I'll note that these records are subject to a protective order.
Okay. Well, Your Honor, I'm looking to. I believe that we can use these records during this particular hearing in front of the hearing officer. So, Your Honor, if I may, if I could share you my screen, I can show you how confusing these records are.
Go ahead.
Your Honor, this hearing is open to the public, and these are protected by a protective order.
Okay, all right. No, you can't, Attorney Bay.
All
You
right.
can say you can mail me a copy of them, and I would like to see them. So you mail me a copy with copy, obviously, to the division, which has them already, I assume.
Thank you. If I could just describe what I'm looking at, Your Honor. On one particular search, Your Honor, I'm just estimating about 10 different entries with SB's name, which is very confusing, on the same date at the same time. And then it's unclear as to how this particular search for SB was done, whether it was done by VIN number or plate number. My client contends that if he did ever search for SB's name, it would have been by his plate number, and it would have been inadvertent as he drives around Stoughton, conducting his regular patrols, Your Honor. However, when you look at these records from CJIS, there is simply no way to tell that, aside from this completely speculating, because you see the SB's name, SB name on this spreadsheet, you see VIN numbers on this spreadsheet, and you also see plate numbers on this spreadsheet. So whether he searched her by name, VIN number, or plate number is completely up to speculation, Your Honor. But without some sort of authentication explanation, the commission would just have to speculate. That's why, Your Honor, when I was imagining that these records would be a lot more clear than they are. When I look at them, you can't figure them out unless you're speculating. That's why I would strongly suggest that this isn't the type of evidence that people regularly rely on in these important type of matters, Your Honor. And this is a situation where my client's license to operate as law enforcement personnel is on the line. And so inconveniencing someone from CJIS, I'm sorry, I don't think is a good reason to just allow these records in and allow the commission to simply speculate as to what they need when it's very unclear.
Your Honor,
Yeah, go ahead.
if I may just respond, it sounds like all of Attorney Bay's arguments are more about the weight that should be given to the evidence and not to the actual authenticity.
Well, they have to be established as authentic to begin with, and someone has to do that. So someone from CJIS could come in, authenticate the records, and then explain what they mean. And could be cross-examined as to whether there's any way of telling whether the searches were made from the Stoughton Police Department or out on the street. And it may be that the answer is there's no way of telling that. Why wouldn't that be relevant to the fact finders?
It may be relevant, Your Honor, but if Attorney Bay is planning to challenge these records, shouldn't it be Attorney Bay who calls the CJIS representative? I'm not saying that the division is not planning to call a CJIS representative. In fact, a CJIS representative is listed on our witness list. However, for example, if a CJIS representative doesn't respond to the subpoena on the date of the hearing, that should not preclude the division from introducing the records, which again appear to be authentic based on the protective order, based on the letter received from CJIS, based on the content included, and the fact that Stoughton clearly relied on these records in their internal affairs investigation and referred to them several times.
Excuse me. Are you planning to subpoena the CJIS representative?
Yes, Your Honor. The division does plan to do so.
Okay, so if the representative doesn't appear, there are ways to enforce the subpoena, I would imagine. All right. Okay, Mr. Bay, do you now have the material that shows whether he sent sexual text messages to SB during work hours?
I do have the text messages, yes, Your Honor.
Okay. Okay. Now, Mr. Martinez, is there a Stoughton Police rule or regulation or any other rule or regulation prohibiting personal text during work hours?
I'm not sure, Your Honor.
I can answer that, Your Honor. There isn't.
Okay. So if personal text messages are not prohibited during working hours, what's the allegation? What's left of the allegation?
It's not just the fact of the text messages, Your Honor. It's that the extent of the text messages, the fact that he's exchanging nude photographs and sexual videos containing sexual content while on duty is very troubling. And I believe at a minimum would meet the standard of unprofessionalism for a police officer.
Okay. So the import of them is that they are of a sexual nature and that some of them are nude photos.
That's correct.
Okay, Mr. Bay, can you stipulate to that?
Well, I can't stipulate to it, Your Honor, because I don't think it's improper, because there's no regulation prohibiting
No,
it.
I didn't say it was improper. I said, can you stipulate that that he sent well, I guess you have a problem with it. They were sent during working hours. Is that right?
That's correct.
No, I'm asking Mr. Bay. Is his problem?
Your Honor, I wouldn't be able to stipulate to something today, Your Honor. I do have text messages between SB and my client. I do need to do some cross-referencing between those text messages and his actual working hours, Your Honor. I wouldn't be able to stipulate to that today, Your Honor. But I can say that there was sexually charged text messages between my client and NSB during the period of time when he was employed by the Stoughton Police Department.
Okay, but you you obviously have the ability to check whether they were during his work hours.
I'd have to check on that, Your Honor. We have a number of subpoenas outstanding, both in this case and the Norfolk case, Your Honor. So I'd have to check to see where we are as far as our subpoena to Stoughton. I know that we do have his personnel file. Whether that includes his working hours, I'd have to check. From what I recall is that there's so much information, Your Honor. I actually have a team of people reviewing this, and thus far we've been able to identify some text messages that were during his working hours, just simply due to the nature of the conversation, i.e., I'm at a detail. Here's another text, that type of thing.
So it's possible that you might be able to stipulate that there were text messages between your client and however we end up referring to this person during working hours.
If it's clear on the face of the text, Your Honor, I anticipate I may be able to, but that's not something I could do today.
No, I understand. And Mr. Martinez, would you have a problem with that, or is your issue that there would be more sexually improper text messages during working hours than are shown by the actual content of the message?
I do think that the content of the messages are important. I don't think that there's an issue with, for example, submitting redacted text messages for the public hearing, but I do believe that an unredacted copy should go to the commission.
And me.
That's correct.
Your Honor, that also takes into account the mentioning of SB's name, Your Honor.
Well, that's it. And I in my question, I said that it would be however we decide she will be referred to. Okay. So just so I understand this, Mr. Martinez, so assuming that there's no Stoughton rule or regulation prohibiting text messaging during work hours, your position is that the nature and extent of them establish unprofessional conduct that may escalate, that is improper. Is that right?
That's correct.
Okay. Okay, Mr. Martinez, is your argument that there is a material difference in the respondent saying that he last met with SB in December of 2020, when it was in fact January 10th of 2021, a few weeks later?
Yes, Your Honor.
Okay. And what is the difference?
Given that it was in relation to the death of an individual, I'm sure that Officer Farwell was aware that the importance of dates, especially in the early stages of an investigation, are extremely important. And despite the fact that Officer Farwell had text messages with this individual readily available, he still failed to provide an accurate date. The text messages that will make up part of the division exhibit, in fact, shows the last time that the two communicated and in fact communicated in person. Given the importance of even these minor details to the investigation of the death of an individual, the fact that Farwell himself is an officer and knows the importance of the difference that a couple weeks can make, and the fact that he had records reflecting the last date that he actually saw the individual are the reasons that the division believes that that's a material fact or a material misstatement.
Okay, Mr. Bay, do you want to say anything?
Yes, Your Honor, I strongly dispute that my client had any records showing that he had contact with SB on this January 10, 2021 date, at the time that he was questioned by the state police on February 11, 2021, over a month later, Your Honor. My client's phone records have not been a subject of discovery. They have not been produced. These are records that Mr. Martinez obtained from SB's phone, not my client's phone. So there is zero evidence that my client had records that he had last texted with Sandra SB on January 10th, at the time of the state police's interview of my client on February 11th, 2021, Your Honor. And I would also state, Your Honor, I think it's significant that my client is being questioned on February 11th of 2021, and it is alleged that he last communicated with SB on January 10th of 2021, over a month earlier, Your Honor, and my client was allegedly off by 10 days, Your Honor. I think we're grasping at straws here to claim that he's being untruthful to the state police. It's not as though he said he hadn't had contact with her. He admitted he did, just he was off by 10 days.
Your Honor.
It's not like he was questioned on January 15th, Your Honor, or January 20th. This is over a month after.
I do just want to state that it may not be the difference between 10 days. I believe the difference is sometime in December versus January 10th. So it could be December 1st or December 31st. It's just sometime in December is the allegation from my understanding.
Okay. All right. Those are all the issues that I have to discuss. Mr. Martinez, do you have other issues to discuss?
I don't believe that there are any further issues at this time.
Okay, Mr. Bay, do you have other issues to discuss?
Yes, Your Honor. If you recall at the last hearing, you wanted to also kind of revisit the issue with the state police subpoena that we had sent out. I still have not gotten a response from that to that, Your Honor. I will say that I have been in touch with State Police Legal, Attorney Brunelli over there. I tried to give him a call this morning again just to kind of see where he was, but the long and short of it, Your Honor, is I've subpoenaed the state police records both in the Norfolk County death case as well as the post case, this case, Your Honor. I have not yet received anything in response to those, Your Honor, but Attorney Brunelli has informed me that he's going to work with me in order to produce the documents. So I do anticipate they will be forthcoming. When that is, I'm not exactly certain, Your Honor. What I did was I informed Attorney Brunelli that of our two different subpoenas from the two different forums, he asked me for a new subpoena in the Birchmore case, in the Norfolk death case, Your Honor, which I anticipate would serve basically both purposes for as far as documents from the state police, since they are state police was investigating to some degree. We're not exactly sure what degree the death of SB. And so, Your Honor, my concern, the reason why I bring that up, Your Honor, is we have this hearing coming up in November, and I'm not certain right now if and when I'm going to get to this state police subpoena, which I don't know what they have. We were just informed about, I want to say maybe 2 weeks ago, kind of inadvertently from due to a subpoena we sent to the Attorney General's office in the Norfolk case. We discovered through an affidavit in the opposition from the Attorney General's office that the state police has been conducting an investigation into this matter. And once we heard that information, Your Honor, we then, made more efforts to obtain this information, because there's really only one document in the internal affairs report that references the state police and my client, which was simply just the one February 2021 interview between the state police and my client. Now it appears that there may be much more than that. So that being said, Your Honor, I think it would be best to possibly either have an interim date between November, or change the November date to a status date, and then hold the hearing later on, Your Honor.
Mr. Martinez, do you have anything to add on that subject?
Your Honor, I would have suggested a status conference before the hearing regardless, and I do think that maybe one in approximately mid-September would be appropriate, so that we can touch base and make sure that that there would be a state police response to the subpoena, and that way we could potentially resolve that issue 2 months in advance of the hearing if needed.
I was planning to order that there be a status hearing again before the actual adjudicatory hearing date, and this is a very good reason for doing that. Mr. Martinez, do you see any way of hastening this response by the state police?
Your Honor, I will note that I believe that the letter that or the affidavit Attorney Bay is referring to, the final clause of that letter, if I'm not mistaken, does say that the Attorney General's office believes that disclosing the records would impede their investigation. So I think that may be part of the issue as to why the state police have not already responded. I could be misremembering, but I do believe that the last clause of that letter does say that the AG's office is against disclosure of those records.
Mr. Bay?
Your Honor, I don't want to speak out of turn, but I'm a little bit behind on my emails, but I'm almost certain I got an order allowing that motion from the death case in the Norfolk Superior Court case yesterday on that. I just hadn't get a chance. I saw a motion was allowed in that case. I got notice of it, just referred to the motion by number. And that's the only pending motion I know of at the moment in the Norfolk case. So I believe the motion was allowed. If you give me a second, Your Honor, I could do a quick check if you'd like.
Go and look. Allowing the motion. What's the motion? For a second subpoena?
No, is the motion to compel the Attorney General's office to respond to our subpoena, which the Attorney General's office, through their affidavit in opposition to our motion, informed that they do have, that there was a state police investigation going on. The Attorney General's has some, but not all of the state police documents. And so that's why it's important that we're getting everything from the AG's office as well as the state police. But I can check that. I can check that motion right now, Your Honor. Sorry, Your Honor, it was, good thing I checked. It was, the motion was allowed was a motion by one of my co-defendants for unrelated records, not the records from the state police. So
Okay,
I think that's still being,
all right, okay, it definitely is necessary to have a further status conference before the November hearing date. And we will hope that we can move forward with the November hearing date and not have to continue that date. But, okay, when, Mr. Bay, you seem to be the one with the busiest schedule. As I recall, you had some problems in September.
yes, Your Honor, I have two trials that my spidey sense tells me are definitely going. One that starts on September 3rd and one that starts on September 30th.
Well, what about in between those two dates?
That's a good point, Your Honor. I would anticipate that my September 3rd date is likely over, I would anticipate I would likely have some availability start between September 17th and September 27th. That would be the period of time where I would not be on trial.
Lizzie, are we still working with Tuesdays and Thursdays for the hearings, or are other dates available?
That's preferable, but we could do other dates, just whatever works for all parties.
Okay. Well, I'm going to suggest Monday, September 16th. Mr. Bay, could you do it then? Mr. Bay, September 16th?
I anticipate, so I anticipate my trial will be over then, Your Honor. If we can just, you know, if in the case my trial does run over, I may have to continue, but let me just make sure I'm available on that date as well. Yes, Your Honor, in the morning on September 16th, I could do.
Sure. Let's double check. Mr. Martinez, the morning of September 16th?
That works for me, Your Honor.
A fall has been detected. Dialing the emergency response center now. To cancel a call, please press your call.
All right, the morning of September 16th, so that would be 9:30 on September 16th. And that will be by Zoom again.
Yep.
All right, is that date agreeable to you, Lizzie?
Yes, that works.
Okay. Okay. Okay, so are there any other matters that we need to discuss today, Mr. Martinez?
No, Your Honor.
Okay, Mr. Bay?
No, Your Honor.
Okay, thank you both. Thank you, Lizzie, and we will meet again on the morning of September 16th.
Thank you, Your
Thank
Honor.
you.
Thank
Have a
you.
nice rest of the summer. Thank you.
Too.
Bye.